Good morning, friends. Let us remember the father of nation, Mahatma Gandhi ji, and also Sri Lal Bahadur Shastri ji, who were born on this particular day. And let us remember their great activities and sacrifices for the nation. Right. Now, our today's topic is regarding the judgment on Babri Masjid demolition case, right? The special CBI court, Lucknow, so it has acquitted all the 32 accused, holding that there is no conclusive evidence to prove the conspiracy, and also the press reports, the originals of the press reports were not supplied, and the video clippings they were not supplied with the seal covers. Therefore, benefit of doubt ultimately goes to the accused, and ultimately the honorable court says the prosecution failed to prove the guilt against the accused. So this is the judgment given on 30/9/2020 by the special CBI judge Sri S.K. Yadav. Actually, on 9/4/2017, the Supreme Court has directed the special CBI court to complete the trial within 2 years and come up with a judgment. But by 2019, the trial was not over because many witnesses have to examine, so many documents have to be marked. It has taken time. Actually, this man, the S.K. Yadav, he was supposed to retire last year itself, but the Supreme Court granted 1 year extension to him for conclusion of the trial. Of course, on the last day of his retirement, that is on 30/9/2020, he delivered the judgment holding all the accused not responsible for the crime, or the crime is not proved against all the accused, acquitted all the 32. Right? Actually, for the last date of judgment, that is 30/9/20, all the accused were supposed to be present in the court, but only some 32 were present and 9 absent. Of course, 9 means like Murali Manohar Joshi, L.K. Advani, Uma Bharati, because of the old age and because they were suffering from corona. Some people, they could not attend. Of course, they attended through the present video conference system. Ultimately, the court acquitted all the accused. Right? So, if we go back, the demolition of Babri Masjid took place on the fateful day of 6th December 1992, at the time of the Prime Minister Sri P.V. Narasimha Rao, and at that time the Chief Minister was Sri Kalyan Singh. Right? Actually, the Ayuja sadhus, most of the sadhus, they went there, they requested P.V. Narasimha Rao, but he maintained stoic silence. Actually, he sent to the Central Industrial Security Forces, but they were actually literally cordoned in the outskirts by the Karsevaks. So many things happened, and we have seen at the time also the videos were there. We have seen the demolition, the dome, drawing away the dome, all these things with ropes, all these things we have seen. Everybody knows that the demolition is there, but the case is acquitted. Now, so many people are getting down, getting so many suspicions that if the accused or acquitted, if they are not found to be guilty for the offence, then who are the people? Do you think that the Babri Masjid was not at all diminished? Is there no conspiracy? And what happened to these people? All these so many doubts. Of course, so many comments against the court also. Please remember, you should not comment on the judges. You should comment on the judgment if you go through the judgment. I tried actually to go through the judgment, but it is totally in Hindi, which we can't appreciate, which we can't understand properly. But anyway, basing on the bar and bench or live law, all these things, I have consulted and giving this. So I'm not going to the merits or demerits of the case. I'm going only to the investigation and trial part. That's all. Logical, only legal points we are going to discuss, because it has sent so many actually political eclairs, political narrative. It has created political narrative for the decades, because 28 years it has taken for the trial. Of course, in the beginning, I have to tell you that there were 2 FIRs in the year 1992 when the incident took place. First FIR, crime number 197 by 92, it says lakhs of Karsevaks, that is accused. And in the second FIR, then they have named L.K. Advani, Murali Manohar Joshi, Ashok Shinghal of that VHP. Actually, he was also present there. So all these people, again in the second FIR it came, and in the meanwhile, maybe in the year 2016-17, some High Court, Lucknow High Court maybe, or Gauhati High Court, sorry, Allahabad High Court, they have removed the names of the so-called L.K. Advani and others from the charge of conspiracy. But still, in a stunning judgment, Supreme Court held that the trial should be completed till such time they cannot withdraw the conspiracy charges. Then with that intention, with that only, the trial has taken now a speedy pace, and luckily it was disposed of. The outcome may be anything, we are not with that. So please remember, the judgment will depend mostly on the evidence produced before the court. That's all. So even though we know, that's why in Chundur case also people ask me, when the Chundur case accused or acquitted, they said, so that means nobody killed these Chundur people. It's not correct. Please remember, the judge will decide the case on the merits, the case on the basis of evidence. The evidence produced before the court, whether is sufficient to prove the accused guilty for the offence or not. That's all. Right? Now, let us go to our legal points. At that time, the Supreme Court, of course, you may be knowing about 1 year back, this Ayodhya judgment, it has also come. Of course, something it is somewhat balancing, and people think that it is in favor of Hindus. Okay, whatever it is, the judgment was somewhat balanced judgment has come. Same Babri Masjid issue. Right. Now, but in the anti-climax, all the people are acquitted nowadays. Right. Now let us know the legal points. What are the sections of law under which the case was tried? Right. The basic section, the fundamental section is 120B, the criminal conspiracy. Judge says there is no conclusive proof to hold that there was a criminal conspiracy. So section 120B, it tells you about the criminal conspiracy. Please remember, for forming the criminal conspiracy, there should be minimum 2 members, meeting of minds. So one should indicate or one should explain his plan to the others, even though the conspiracy is proved or it ended, whether action is taken or not, whether any armed rebellion takes place or not, but meeting of minds is sufficient. If act is done or not, immaterial. Right, here there is an act, it was done, but anyway, so the criminal conspiracy is not proved. Section 120B IPC. Then section 147 and 149, you have to read them together. So section 147, you have to know what is 144. 144 is about the unlawful assembly. If any gathering of more than 4 people or 5 or more people gather with intention to commit a cognizable offence, it is unlawful assembly. If the unlawful assembly is armed with weapons, it is 147. 149, if there is any common object for all the people, that means so many people may be gathering there, so all of them would not have beaten, all of them would not have demolished, but the persons present there, you have got the intention of demolishing the so-called Babri Masjid, they are also liable under section 149. Please remember the word of common object, common intention, common object. Common intention there in section 34, common object in 149. Right. Now, another 2 important sections they are also booked. They are 153A and 153B. 153A, nowadays it has become a common and we know. So 153A IPC says regarding the creating of differences between 2 groups basing on the religion, and let us for this same things are there basing on the religion. 123B, so they are relating to imputations and assertions which are prejudicial to the integrity of the nations. Right. Then section 295 and 295A, both of them are most common. Section 295 says injury or defiling the place of worship. Suppose 295 is saying that Anjaneya Vigraha, this hand was broken, some people desecrated the statue of a great famous leader like that. That is section 295. 295A, that is deliberate act, deliberate and malicious acts intended to outrage the religious feelings of any class. Almost 153A, similar, but 25 is a very simple offense, petty offense. Then section 505. 506, you may be knowing, criminal intimidation. 505, that is statements conducing the public mischief. So do it, come on, let us do like, if they issue the statements like that, then it attracts section 505. Then almost I think these are the sections, of course, 323, 324, so many sections they have added, but these are the important, 332, that is causing injuries to the police people also. But please remember here, in this connection, I came to know that so many police people and even the administrative, revenue people were present there, but they were given strict orders not to use force, that means not to use firing. So that's why they became mute spectators, and definitely, so the Babri Masjid demolition went on that fateful day of 6th December 1992. Right now, the CBI court held that there is no record, there is nothing on record to establish the existence of conspiracy to demolish the Babri Masjid. No evidence, please remember, nothing on record, right? So here you have to remember that the judge also commented that about Mr. Ashok Singhal. So no conspiracy, no premeditated plan is there, and the persons like Ashok Singhal and others, they were at a distance of about 800 meters from the place of demolition. They in fact wanted to subside the issue, and they in fact given warnings, and they have requested the people not to demolish the same. But the Karsevaks, who at the time of who got the grave and sudden provocation, they did not care the pleadings of the so-called Ashok Singhal, and they went ahead. So the rowdy elements or rowdy Karsevaks, they have done all these things, and it went out of the hands of the so-called leaders, and that's why there is no criminal conspiracy. Right, as far as so many witnesses have been examined, so about their evidence, so due to the demolition, lot of dust was collected. Therefore, they said they are not able to identify these persons. That's why lacks of cursive. That's all, no identity. So no use of oral evidence, and conspiracy could not be proved. Now, this will be based on so many press clippings, so many presses, and because media persons were present, they have recorded, and it has come in the press also. They have produced the press clippings of various papers, but the court says the original press clippings were not available, only Xerox copies were given. But whatever it is, even the original press report was given. What happens, you may be knowing, according to section 78 of the Indian Evidence Act, the press clippings, nobody will take action. They are only hearsay evidence, they are only secondary evidence. No credence need be given to the press clippings unless they are approved, unless the original is obtained. So this is the celebrated case of Lakshmi Raj Sethi versus State of Tamil Nadu, 1988. So it held that it is only secondary evidence under section 78, and it of Evidence Act, it has no value. The court mentioned this judge case also. Right. Next, press clipping gone. Then they have produced, the CBI produced many photographs. So from the demolished site, and it was also demolished, dismissed, stating that the negatives of the same were not produced to the court. So unless you have to produce the negatives, otherwise how can you mark the document without that? Did the CBI not know this? Very funny. And as regards videographs, so they have produced so many video. Apart from the press reports and photographs, the court also considered videotapes shown by CBI. Of course, they have considered, but they did not take it as evidence, but refused to rely on the same, as the videographs were not submitted in sealed envelopes. That means videographs were open. And secondly, the footage was not clear. Of course, after 28 years, how can you expect? Nowadays, the video cassettes have gone. Now CDs and so many pen drives have come. That is the technical defect. Nowadays, we cannot do anything. So, please remember, basing on these 3 points, the case gone fat, went into acquittal. The court also had that the BJP leaders, So the so-called hurting the sentiments or spirit of another. So it is not proved. The court opined that the accused has no knowledge or premonition that, but a group of rowdy elements, they have demolished the structure. Of course, the court has come to the opinion. So already I told you there are only two wings which do not have any bosses over them. Number one is judiciary, second is the press. They can write anything. So only thing is you have to go in appeal, that's all. We don't know whether CBI will go in appeal or not, because famous leaders, famous BJP leaders or famous leaders of the party in power in the center like L.K. Advani, Murali Manohar Joshi, Kalyan Singh, Uma Bharati, Ashok Singhal. So many people they are figuring as accused in this case, we don't know. That's why Mr. M.K. Stalin yesterday commented, even previously Karnataka also commented that CBI is a caged parrot, Panjaranlo Chilaka. So So now the points for discussion. So now, okay, the court said that the judgment is based on mainly on these points. Now what are the relevancy? Now you have to, no doubt, CBA people failed to act proactively, failed to produce the originals, failed to produce the negatives of the photos, failed to produce them in the sealed right, okay. But is it that much difficult for the court to secure the videos, demolition videos? They are very much available on the YouTube, if they say, if they are satisfied. That's why in certain cases moral conviction will be there. They need not go evidence straight on the basis on the evidence. Yes, definitely they can go through some other sources. If you search the YouTube, definitely you can find so much of video coverage of the Babri Masjid demolition. There are so many press clippings. If you ask for the original, don't they give? Of course, court thinks it is not our duty because it is the burden of proof lies on the prosecution, not on the court. Of course, that point is also there. But anyway, the people misconstrued it. The judgment, definitely they are under the impression that the judgment is to please the party in power, the bosses are in power. So now normally the court will always be saying whether there is rule of law in AP or not in India, like that. Now whether there is rule of law being executed by the Supreme Court or not, because the justice not only should be done but should appear to have been done. But the wrong message has gone to the public. Of course, no doubt they cannot comment on the judges, they will keep quiet, but they will keep in mind that justice was not done to the common man. In this case, then I told you the moral conviction. Normally on seeing this so much of demolition, so the moral conviction should have been given, but anyway, it depends on the judge and the that is appreciation of and second point. Now you see the funny point, the BJP leaders who claim that Shiv-Sena, BJP, all of them in Maharashtra elections, they stated, we demolished the Babri Masjid, but as far as the court is concerned, when they came to the court, they said, no, Your Honor, we do not know anything, we did not do anything. Then who did it? Don't the leaders have that much of commitment? Here we have to remember Mahatma Gandhiji. Yes, when he was put in the court, he said, yes, I did it. I will do it. Even though you release me, I will do it. That's all. That is the commitment, my Papa. These people politically say one thing in the road, and when they go to the court, they do not have commitment. They said, we do not know anything, Your Honor. We are not coming. What is this? That shows the commitment of the politicians. Then, now, who were the reality elements? Say, normally at that time, you may be knowing, of course, youngsters, you may not be knowing. In 1992, people who are youngsters, yes, we have all seen. So, at that time also there was so many Karseviks. We have stopped some of them, but some of them fled away. So many of them went there, and so many of them brought the bricks. Jai Ram, something it was written like they have brought bricks. So, why all of them went? Did they go to conduct bhajan in that Babri Masjid area? Isn't that common sense? Right. Anyway, and the last point I will tell you is the date of retirement is coinciding with the date of acquittal also. Right? Of course, we should not comment. These are only points. Anyway, let us see. So, and all of you know that Ratha Yatra was taken by L.K. Advani before 6/12/1992 itself. Right? So, these are the intricacies. Anyway, case ended in acquittal. We cannot do anything. And conclusive evidence you will be knowing. Section 4 of the Evidence Act says that conclusive evidence means you should not seek for any other. If you may presume, shall presume, and conclusive proof means you should not go for any other evidence. But conclusive proof is that conspiracy is not proved. So ultimately, the case ended in acquittal, and we have to see whether the CBI will go in appeal or not. Right? Thank you very much.